Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. We'll start in Miami-Dade. This is Judge Andrea Ricker Wolfson. That's a mouthful. Sitting in for Judge Grumpy Pants. Let's see what she's all about.
Is present.
Mr. Rodriguez Moreno has a warrant from St. Johns County
Señor, tiene un orden de arresto del condado de St. John's
from June 25th of 2024 for failing to appear in court.
del 25 de junio del 2024 por falta de comparecencia delante del tribunal.
There is a bond on his case, $2,000. Can we reset the case to see 15 days to make sure he either posts his bond or gets picked up?
Tiene $2,000 de fianza. Están pidiendo reiniciar el caso de aquí a 15 días para ver si o pone su fianza o lo recogen.
Sir, your case will be reset to 7/17.
Señor, su caso va a ser fijado ahora para el día 17 de julio.
Good luck to you, sir.
Buena suerte, señor.
All right, that concludes the in-state extraditions. I'm going to take a 2-minute restroom break and we'll get started with the regular calendar.
Good.
All right.
And just that quick, we're done with her. So be it. Let's go to Michigan. Judge Middleton, who a little earlier this morning was doing arraignments, I believe.
As I said, the most serious charge is operating while intoxicated. In Michigan, it's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It carries 6 points on your driving record and requires that your license be suspended. The other charge is a misdemeanor punishable by up to 90 days in jail and a fine of up to $100. Says you were eastbound on Chicago and bike lane, passing cars, turned southbound on Clay, hit them. Multiple subjects in vehicle fled scene. So it doesn't look good. It says blood alcohol 0.1. I'm not sure what that means. You live in Indiana?
Yes, sir.
What do you do, sir?
I work at Myers Distribution Center warehouse.
This is an ordinance, Sturgis ordinance case, but Mr. George, I think the wise course might be to get counsel to help this. Do you have an Indiana license?
Yes, sir.
Are you missing work now?
No, I actually rescheduled my off day for today.
All right, well, I'm gonna schedule another off day. I'm gonna set a attorney pretrial for Friday, August 1st at 8:30. I'll appoint an attorney for you. I don't know very much about this other than what I read you off the face of the ticket. Your lawyer will get the police report, laboratory reports, photographs, anything else that there is as part of the file, and be in a position to discuss this with the prosecutor. What you need to do is contact your lawyer, make an appointment to discuss this with him prior to that August 1st date. As far as I can tell, you got no baggage on the Indiana license. No tickets, no nothing. Is that correct?
I got a ticket before for exhibition driving.
All right, well, it doesn't show up on here, but we'll see what the deal is. All right, you go out to the court office with the court officer and we'll get a lawyer to assist you with this. All right, we had a guy who's here today. He was supposed to be here yesterday, so let me get up to speed on this. Put it in my queue. No. My AEL.
Your Honor,
Yes,
Mr. Soto is going to be pleading not guilty, and he just needs a pretrial to have some time to get his insurance certificate.
all right, you're Yael Soto,
Yes, sir.
you live in Three Rivers?
Yes, sir.
You got stopped for disobeying a stop sign and operating without insurance on June 12th. No insurance is a misdemeanor, punishable by up to a year in jail, and a fine of not less than $200 and not more than $500. Let me put a note here. How'd you end up getting your days mixed up?
Just forgetting, sir.
Well, you did the right thing. We'd issue a bench warrant. In your case, I did a show cause, but if you miss a court date, just show up. We're here, open every day of the week. Fridays are a little bumpy because they're not generally criminal days, but if you show up, we'll address your case. No bench warrant. All right. How much time do you need?
To get the insurance or the proof of insurance, sorry.
Yes.
9:15 today.
No, all right, so you're gonna get it today?
Well, I have insurance, but they're not open till 9.
Oh, I see. So,
Oh,
all
sorry.
right, so, well, how long should I adjourn it?
I think probably a week would be sufficient, or would that be enough? A week?
Yeah.
Are you missing work right now?
Yes, sir.
Where do you work?
Commodore Homes in Indiana.
I'm sorry about that, but we would have court during the day and a lot of people work during the day. All right, I'm gonna continue this to, I'll still be here next Thursday, July 10th. Defendant will get insurance. What do you guys build at your place?
Modular homes.
No. Maybe they don't have as much as up and down as RVs do.
That I'm not too sure about. I'm not necessarily in the building section. I'm a drafter.
Oh, okay. Well, Thursday, July 10th. At 8:30. Bring proof of insurance. County prosecutor asked that we set their pretrials all for Thursday, so we've been doing that. All right, Mr. Soto, thanks for coming. A day late is better than not at all.
Yeah, I
So
apologize for that.
set pretrial for 7/10/25 at 8:30. All right, you're good to go.
All right, thank you, sir.
We apparently have another guy that showed up today. But, yeah. In the meantime, Felicia Slater got charged with driving suspended and no proof of insurance. He already has a case set for July 11th for driving suspended. She owes $800 worth of unpaid tickets. She's got several different cases, and she just doesn't care. She was on bond for the other driving suspended when she got this one. I'm gonna sneeze. Excuse me. I got that from you, Jeanette. I don't know what to do about Felicia Slater. She doesn't care. She just does what she wants. She doesn't show up. She got multiple unpaid tickets and she keeps driving. I guess we'll do a bench warrant. Not gonna do an order to show cause. 48-hour hold. On $1,000, which is a little less than she owes. Cash or surety. Ms. Slater, you need to get in here and take care of this. If nothing else, you can plead not guilty and I'll appoint an attorney. Set both cases for July 11th. I don't have the paperwork on this next guy yet. What's your name, sir? Well, thanks for being here. Tim, our in custody case is Janaja Holmes, an old 2021 2378 OT driving suspended, and a 2025 3 hours ordinance retail fraud. So I'm gonna see her by Polycom in a minute. Mr. Coleman, hopefully they'll bring me your file so I know what it was you allegedly did. Not my cue.
Sorry about that. Those are issues. This is Mr. Coleman's.
Thank you. All right, Shaquan Coleman, would you come forward? Good morning, sir.
Good morning.
Give me a minute. I'm gonna get your file pulled up here.
Well, he gets stuff pulled up. Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Wednesday. Probably based on what I'm seeing so far, it'll be a little less court hopping today and perhaps a little more hanging with a court for a while, but we'll see how it plays out. I will tell you breaking news for those of you who might have been following it. The jury has reached a verdict in all of the charges against Sean Diddy Combs. I'll keep an eye on that and let you know. As of last night, they were hung on the first charge, but had reached a verdict on all the others. But apparently they all want to go home for the holiday, so we'll let you know what happens there.
Broadway and Constantine Street. No plate. 40 mile an hour and a 25 mile zone. Revoked license. Open intox in vehicle. Vehicle not insured. So a little bit of everything. not sure what the deal is. Or you had an attorney pretrial on May 2nd. You have a lawyer, Luke Knopfsinger, on this. You didn't show up.
Yeah, I couldn't make it. I'm sorry.
All right, well, you're here now. On a bench warrant. Well, let's sort this out. So, and obviously you had somebody drive you here today, which is good. You got arrested in Kalamazoo on our bench warrant?
Yes, and I paid $500 to get out, and they said today was my court date.
Did you ever talk to your lawyer?
No, he said that he couldn't find my file after I got out of jail, and then he said go to the arraignment to see.
But I mean, before May 2nd, or April, yeah, May 2nd, when you were supposed to be here, did you ever talk to him before that?
Probably like once, but never just to get like really no real information from him.
This file isn't very clear. Usually there's some notes in here or something, but here's my notes. You were here on March 25th. You pled not guilty. I appointed an attorney for you. Set it for May 2nd. Then you didn't show up on May 2nd. We issued a bench warrant with a 48-hour hold. And your lawyer tried to get a hold of you. And then you got picked up. When were you picked up?
I was picked up June, I think 25th or 24th.
And you got out on the 26th?
Yeah.
Well, I'm going to recall the bench warrant. You made this a lot harder than I had to be. You didn't need to go to jail for this, but now the good news is I got $500 worth of bond. I'm going to pay to a fine. I'm going to reset the attorney pretrial for August 1st. Are you missing work right now?
I'm self-employed landscaping. And
Is it hard for you to get back and forth down here?
yeah.
Well, you need to get here.
I
I
know,
mean, this
I know.
is, you're going too fast. You got beer in the car. You got no insurance. You got no plate.
You're right.
Please pull me over. I'm gonna drive around too fast with no license plate. Oh, by the way, I'm suspended. It doesn't even make sense, but it ain't something that is gonna be terrible. As I said, you've already got 2 days of jail credit and I got $500 of bond. I'm gonna ask the bailiff to take you out to the counter and get you a new notice of your attorney's name and number. Now, there's a driving record in here. You're revoked. You got a lot of baggage in Kalamazoo and Grand Rapids. And I think that we took a lot of baggage, holy smokes. So I don't know what you were doing driving around in Three Rivers that day in March without a license plate, but we ought to be able to sort this out. So this is charged under state statute rather than ordinance.
What does that mean, sir?
Well, that's a good question. If it was in Three Rivers case, the Three Rivers city attorney would be handling it. But because it's charged as driving suspended second offense, it's punishable by up to a year in jail. So the county prosecutor is handling it. And it's the same statute, but it's prosecuted by the county prosecutor rather than the city attorney. So really not much of a difference. Anyway, I'm gonna get you a new notice with Luke Knopfler's name and number on it. He'll be willing to talk to you. You can talk by phone, you can come down and meet with him. But we need to get this resolved. And like I said, I got $500. When we get to where we're going, I've already got money to apply to your fine.
Okay.
So you're good to go. Thanks
All
for
right,
bringing
thank
it
you.
here today.
Thank
All right, we have 3 pre-trials. Did any of them show up?
One of them's in custody, Your Honor.
Oh, who's that?
Christina Drake.
Oh, well, we'll see her then.
So we would have an offer for her. We just wanted to do it in here. She's charged with a trespass and a retail fraud. We dismiss a trespass with the plea to the retail fraud.
Hi, Judge Middleton calling. Could I see a couple of customers? First, Christina Drake, and then Janaja Holmes. Oh, she's here at the court. All right. All right, thanks. Bye. Christina Drake is here live and in person.
Yes, sir.
All right. Let's see how long she's been in jail. Did I see Christina Drake? Is there any else back there or just her? We got so used to never having people here. That lockup is not a good place to be. She has 5 days credit. She has another retail fraud out there somewhere. 1147. Shayna, could I have Christina Drake's other retail fraud case? 251147 SM. Not sure what the status of that is. We got plenty of time. We'll try to take care of everything we can. Good morning.
What's that? Yeah.
Well, it's set for pretrial tomorrow, Tim, and that's not your case. That's a state statute case, so I'm gonna be stuck with this. Good morning, Ms. Drake.
Good morning.
All right, we have 2 files before me. Christina May Drake, file 25343OM as a retail fraud under Sturgis ordinance that allegedly occurred on March 25th of 2025. Under Sturgis ordinance, retail fraud is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. Second count, trespass, 25344OM, Sturgis ordinance, also 90 days and or $500. The Sturgis City Attorney, Mr. Tim George, is here. He's agreed to dismiss the trespass charge if you plead to the retail fraud charge. Ms. Holmes, I'll be with you in a minute, all right?
Yes.
It's alleged that you were at 400 West South Street. I'm not sure what that is. All right, Miss Drake, this is Jeanette Jackson. She's from the Public Defender's Office. And Mr. George, as I indicated, is from the city. You've been in jail for 5 days for this. My inclination is to give you time served, but you have another case.
Can we do it all at once? Or does it have to wait till tomorrow?
No, we can do it all at once. 1147. The other is that on May 5th, you were in the gas station. Two bottles of liquor. Gentleman Jack and Bacardi line. So that's also a retail fraud. It's punishable by up to 93 days in jail and a fine of up to $500. You are really struggling. All right, so Mr. George would dismiss the trespass charge if you plead to the retail fraud charge in Sturgis. You also have the other retail fraud charge from White Pigeon under state statute.
Sir,
And that's set
I
for
just want to say, I am working. I have been able to obtain a vehicle, and I'm already I've already applied and been accepted through SNHU. I'm going into a recovery coach program. I'm trying to change things in my life, and I feel that would be my best option, is to get into a program where I'm working with others who are struggling in the same area I'm struggling in.
And what is your main problem? Alcohol?
Yes, alcohol.
Didn't you work at Doc Foundry or something at one
No.
time?
No,
Oh, that's a different lady.
but
All right, so are you
I-
willing to plead to these charges?
I am, sir, but if I'm kept too much longer, I'm not gonna be working or have that.
Where do you work?
opportunity. Well, I've been working, like, I've been self-employed, but I've been helping clean out, storage units in Bronson, and, they have some more in Coldwater. But if I'm, right now, because of the holiday, it's not really gonna be a big issue. I'll be able to start working again, and I know that these are financial crimes, and I really just want to get back to work and start paying back my debt. And like I said, I really feel that if I can get in a program where I'm working with people who are struggling, the same struggle I am, like this program through SNHU, I really feel it would help keep my feet on the ground and making strides in positive direction.
You're a mess.
I am.
And everything you just said is a bunch of words that really have some substance, but
I was able to buy a truck. I'm just working on getting money to get it legal. And I mean, I know that it doesn't really mean too much when I'm sitting here facing 3 charges, but I am.
and you've got a felony charge in circuit court.
Yes.
That was bound over in May, and you're on felony bond, and you're still out stealing stuff. Now the one was in February. You didn't show up.
That was because I was locked up in Elkhart.
All right,
And then the next time that I had court in June, I messaged my lawyer and asked him if he could get it like rescheduled to when my next court date was on the rest of my stuff because of work. And it said that he got the message, but he never responded to it, so I attempted to, do something about the one in June, but it was because I was working.
All right, who lives at Congress Street?
My husband
So are you
and
there?
children. Not at this time.
So are you still homeless?
Technically, yes, but, as soon as I get this truck legal, I can get a real job, like, on the books. That's what I've been working towards. I got this F-150, and now I just got to get it legal, and I could get a job that's, on the books, that I'm punching a time clock. And I really am trying to hold myself together. Like, when they picked me up, I wasn't on anything, and I was proud of myself that, even though I was going back to jail, that I was clean. I didn't have any alcohol in my system or my possession. I'm
When did
really
you get
working
picked
towards-
up?
I'm sorry,
When did you get picked up?
last Thursday.
How did you get picked up?
I was walking down Centerville Street. I had just had dinner at the park with a friend, because they have them girls at the park. And we were walking back towards my brother's. I'm not technically homeless because I've been living with my brother. I haven't been living in the homeless communities or anything, but I don't have a home of my own.
You're not welcome to come to your husband's house.
No, we've been separated for about 9 years. But my brother lives in the trailer park in Sturgis, and the one behind Granby's. And that's where we were walking back to when Officer Ware seen me, and I had the active warrant.
And you knew you had active warrants.
Yeah, so he came and picked me up. I didn't know I had active warrants. He said it had just come out 2 days before that.
Well, you didn't show up for court on
Right.
a couple of different occasions.
Well, that like I said, I messaged my lawyer, so I wasn't sure that was even a warrant. Because I messaged my lawyer and asked him if we could reschedule it for when my next court date was, because I was working at, and was able to obtain this truck. And I apologize that I didn't call the court myself, but he had told me if I messaged him, that he would get it, and that, anything like that, I was.
Well, that's in your felony case. You don't have a lawyer in these cases.
Well, I didn't know he couldn't handle the others. Sorry.
All right, well, are you willing to plead to the retail fraud from February? Where was that, Mr. George?
It was at Meyer and Sturgis.
What would I be looking at time-wise, do you know?
1,000 days plus 4 million after that. I don't know what to do with you.
I know.
You talk a good game, but you got multiple theft charges. You're bound over to circuit court on a felony case of theft. You don't show up when you're supposed to. You're like Tracy Chapman in Fast Car. Things are gonna get better and you're gonna move out of the city.
Well, I've been I've been checking in with community corrections. I mean, I've been doing everything so that I would be holding myself accountable, sir. And I apologize for my mistakes, but if you'll give me the chance, sir, I'll show you I'm really meaning what I say. And with me checking in with community corrections, if you don't feel that the steps I'm taking, if I'm released, are in that direction, I mean, I can always be picked right back up, just like I was.
That's always true.
And I'm not trying to pull the wool over anybody's eyes. I'm just trying to do better for myself, and my children.
Now, at one time you were struggling with meth. Is that not a thing now?
That's not a thing now.
But I don't think you have a valid driver's license.
Yes, I do.
Do you?
Yes. I actually just got it in the mail, because my husband has been keeping my mail for the past 7 months and I didn't know it. And so every time I would have stuff sent there, he wouldn't give it to me. So I had my mail held at the post office and I have it in my personal belongings. Yes, sir. I do have a valid driver's license. but even a restriction on that can make sure I don't go too far out of the, too far out there. But when I do get this truck legal or something, I don't know. I'm willing to work with you. I just want to keep making steps in the positive direction, sir.
What do you have in Elkhart?
It was a public intox. I did 5 days on.
Well, we were looking for you on 2024-52, resisting, obstructing, yield fines and costs. We talked to your ex-husband, told us you were in Elkhart County Jail.
Yeah, I had been at one place drinking. It was the day after my dad went to jail, and my dad's girlfriend insisted I come back to their apartment. So I went back to their apartment, and an officer picked me up for being drunk in public intoxication. And so I did 5 days there.
All right. Do you wish to plead to these charges or not? I'm not. All right. So let's talk about the first one. Anybody threaten you to get you to plead to that ordinance case from Sturgis?
No.
In February at Myers?
No.
What did you take?
I don't even remember, sir.
Can you
was
tell
a
us,
long
Mr. George, what it was?
It was a number of items. I think there was some nails, a hammer, some extension cords, and some food. The total amount was $157.12, but it was all recovered.
Hammer and a hip. My smells clean. All right. So do you acknowledge that?
Yes, sir.
Do you understand, Ms. Drake? And this applies to you as well, Ms. Holmes, if we enter a plea in your case. Do you understand that if you plead any of these charges, to have a trial in front of a judge or jury? Do you understand?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. You have to do is ask for you. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court, so they could be questioned under oath. You would have the right to take the witness stand yourself and testify on your own behalf. You have to, because you have a right not to testify, and if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be innocent as the state would prove your guilt beyond a reasonable doubt. Understand?
Yes, sir.
We're
May
gonna-
I ask,
yes.
with the hesitation on me being back on the community and everything that I'm saying, what if we do a probation for my misdemeanors? I'm still awaiting this felony too, but what if we do a probation where I'm
Well,
checking in?
I may try to
regularly?
figure that out, so let's talk about that.
Okay,
All right, so, and I think finally you have a right to be presumed innocent unless the state we are guilty. So let's take straight up front.
because I really think probation would be the way to go on making sure that I'm being held accountable and that you're not just letting another criminal back on the streets to commit more crimes. I understand that that's how it goes. I completely understand that.
All right, I'm gonna order in that one 5 days, credit 5 days. Minimum fine of $120, 2 days. Seven, 2. Concurrent with the other retail front, which is 2.5. All right, let's talk about that one.
Okay. In that case, sir, I'll tell you exactly what happened.
All right, well, let me get to it. That case,
I was with a
well,
woman.
slow down.
Okay.
Alleges that you were in the Shell gas station on
Yeah,
May 25th.
I didn't even know that they came after me with these charges because
All right.
I wasn't aware.
So did you take something?
Well, that's what I was gonna say. I wasn't even aware that they were coming after me with these charges because I wasn't aware that they looked at me as if I had taken something. This woman said she wanted to get these 2 bottles, and she was up at the register paying, and I grabbed them, and they knew I grabbed them, and I walked out of the store with them. Now, I didn't realize she didn't pay for them. So I wasn't aware that they were coming after me with these charges, but I did not, I was in her truck. I mean, they didn't even come out and say anything. Nobody did. I just went out to her truck, but I did walk out the store with them, so I will take the charges, but it wasn't for me. It wasn't even anything I intended to steal, sir. I just didn't realize that she didn't pay for it.
Stop.
I'm not making excuses.
Yes, you are.
No, I wasn't.
Stop.
What, okay, what did they say?
I was interacting with Drake and Nickerson at the same time. Nickerson said she wasn't sure who Drake was. She was a friend of a male subject. I asked where Drake went. Nickerson said she thought she had left. Then they told the lady not to come. Then they watched the surveillance videos, showed several angles from several cameras. The second video of the liquor aisle at 417. In the video, a subject enters the liquor aisle. That's you.
Yes.
The subject removes the gentleman jack from the shelf and puts it in a large black handbag. The subject moves to the Bacardi Lime and removes it from the shelf and places it in the same black handbag. The subject then moves to the back of the store to an empty Subway shelf and adjusts the bottle so they cannot be seen. Subject walks to the Subway counter to get something from the clerk, and when she returns, it's Christina Drake. So, do you want to admit to stealing these 2 bottles of liquor? Or do you want to tell me some goofy story about
No, that was.
All right.
That was my understanding of it, was that she was paying for them, but I admit.
Stop.
I am admitting to stealing.
All right.
bottles.
Okay. All right. Anybody threaten you to get you to plead to that one?
No,
All right, you're barred from Myers.
Yes.
The other one, you're already barred from Myers. In this one. This one. This last one. Get the file straight. Same thing, 100 additional days. I'm going to order 30 days, credit 5, leaving 25 days to serve. You're recommending a probation. I'm going to see if I can find some sort of placement for you in a treatment.
sorry, what was that?
I'm going to see if I can get Pivotal to find a placement program.
Okay.
30 days, credit 5, may be released to treatment program.
Thank you, sir.
I can't, you're just gonna be in jail for a while. Now, you got a felony case thing for other thefts. They felt seriously enough about it to bind it over to circuit court. I'm not sure what the plan is there. You're barred from Shellmart. Pretty soon you won't be able to go in anywhere.
I know. I'm working on changing that, sir.
Plus, you have so much license baggage. I'm amazed that you have your driver's license back. Michigan license?
Yes.
All right. I'll send an email to the jail pivotal coordinator and see if they got any ideas. Otherwise, if they can't find something, you may just sit for the next 25 days minus good time. Should be about 21 days. But I was disappointed when you were still tap dancing around the fact that you just stole his stuff and you
I
wasn't
apologize. I really,
so you're so much alcohol over so much time has compromised your brain. 5 days clean is a good start. So we'll see. I'm gonna email the jail and see. So someone may be coming to see you to talk about options. All right, you're good to go. Did either Patrick Jones, William White?
There we go. I had the wrong stuff set up. I hit a button and something else came up. Hi, everybody. Real quick, for those of you who might be joining us for the first time and is wondering what in the world is going on in the chat, because we have a very eclectic chat here today. So yesterday, we got off on this discussion about TV shows. So I proclaimed it that today would be Music Day. So we're talking about music that we like and stuff like that in between court. Also, with regards to the Diddy thing, so he was found guilty on counts 3 and counts 5, which are both of the Mann Act charges. Those are the ones where you are transporting across state lines for immoral purposes. That charge has been used for decades now, and it's a pretty easy one to do. I did see this thing earlier today before we went live where they were interviewing a couple of attorneys, and they were explaining about how hard it is as an attorney to describe RICO and how it works and get people to fully understand it. So their feeling was if he was found not guilty on the RICO charge, it was just simply that. Juries have a very hard time wrapping their brains around it. So I think that probably explains what happened there. Anywho, let's go back to Judge Middleton for a little bit. As I indicated, I think there's going to be a little less court hopping today and probably staying with the court for a little while longer just based on the action. But we'll see.
Last night. Let's figure this out. So, Ms. Holmes, when did you get arrested?
So this was yesterday.
Where?
I was actually on my way home and the person that was driving got pulled over and I was in the passenger seat and I got arrested for my warrants.
All right, where is home?
3 Rivers.
What's your address? The Stiller River Road address?
Yes, 18211 South River Road.
Where have you been for 3 years?
I've just been working. I haven't been in trouble. I haven't been doing anything really stupid.
Where do you work?
Peterson Spring.
Do you have kids?
Yes, I have an 8-year-old. He's with his dad right now for the rest of the summer.
So they just pulled this guy over, found these old warrants for your arrest.
Yes.
And picked you up. All right, well, this is living proof that ignoring things doesn't make them go away. You just blew these off. We had a lawyer, we had a trial, we were ready to resolve the thing, and then you just didn't show up. Then you got caught stealing something, or allegedly, and then you didn't show up for that either. So I'm going to let you out of jail on your promise that you will show up for court. One option, I could just leave you in jail until the next available date, which is August 1st. So I could leave you in jail for the next 27 or 28 days, and then we'll deal with it. That'll make sure you show up. We're gonna have to get a different lawyer for you. I'm gonna appoint attorney in both cases. Luke, well, yeah, in both cases, because Tim George can't represent you. The original charge was only driving suspended. Mr. George probably was about ready to work out some sort of plea agreement, and then you didn't show up. I think I even called you on the phone without any luck. Does your phone number end in 9297?
No, I have a new phone number.
8627?
It's 370.
No, don't tell me on here. You'll start getting random phone calls. All right, so appointed attorney in both cases. Tim George has conflict. I did this arraignment this morning rather than have the magistrate do it this afternoon. What shift do you work at Peterson Springs?
First shift.
So you're missing work now?
Yes.
All right, I'm gonna do attorney pretrial for 8/1/25 at 8:30. I'm gonna set bond of $250 PR in each file. Blowing these off has not been a very successful technique, so let's face them head on.
I agree.
And we can get these possibly resolved by August 1st. If they can't be resolved, you can have a trial. I'll have a lawyer help you with it, but ignoring it ain't helping. All right, so you're gonna get out of jail. We're gonna give you some paperwork with your new lawyer's name and number on it. I want you to call that lawyer and discuss it with them. Tim, I'm not sure what the conflict on the earlier case, because you had represented her as a defense attorney and now your firm is prosecuting her. So you might have to transfer that to the county or something.
Okay.
But you can handle the retail fraud.
Yes, sir.
Anyway, Ms. Holmes, you're gonna get out of jail. You're gonna show up for court. I'm gonna see you on August 1st. There'll be about 412 other people that day. It sounds like it's gonna be a busy day. So it's important that you call your lawyer and discuss it with them first. Have you got somebody that'll come pick you up?
Yes.
All right. You're gonna get bonded out here this morning. You're good to go.
All right. Thank you.
All right, thank you.
I will forward something about how you.
All right, let's change it up. Let's go to Judge Simpson. He is doing his criminal docket this morning.
Prosecution as well as the cost of any emergency governmental services. You understand that?
I do.
All right. And understanding all of that, you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind. All right. You signed an advice of rights form, is that correct?
Yes.
Yeah.
Any question regarding any of those rights?
No.
All right. Look at paragraph 5. There's a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
All right. And because you believe that you are indeed guilty?
Yes.
All right. On June 29, 2024, at the location of 8265 Dexter Chelsea Road in Scioto Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
I had.
And that was evidenced by an intoxilizer result or blood test result?
It was a blood test result, Your Honor.
A blood test result.
Yes.
Counsel, it's the court's understanding that the parties are stipulating to a 0.194
That's correct.
blood alcohol.
Yes, Your Honor.
All right. And Ms. Keedler, you don't have any reason to dispute that
No.
result. All right. Why did the police pull you over?
I hit a mailbox.
All right. So there was an accident of some type. All right. And the police arrived.
Yes.
And that's how the blood test was taken. Ultimately, you were arrested. That's how the blood test was taken.
Correct.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right. Prior to accepting your plea, I do have to advise you that if you commit misconduct as defined under the court rule from the time I accept your plea to the time of sentencing, that any regarding sentencing or any evaluation, the court would not be bound by. You understand that, ma'am?
Yes.
You also could, if you commit that misconduct, could not use that or would not be permitted to withdraw your plea. You understand that?
Yes.
Counsel, do you know of any other promises, threats, or inducements which have led to this plea?
No, Your Honor.
No, Judge.
And have I complied with the court rule, and would it be proper to accept this defendant?
Yes, Your Honor.
Yes, it would.
The court will accept the defendant's plea of guilty to count 2. Should put that in a different spot. Count 1 is dismissed. Defendant is referred to probation. Oh, excuse me, I'm sorry. She's referred to bond sports for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
July 30th, 2025 at 12 p.m.
July 30th, 2025, 12 noon.
Thank you, Judge.
Thank you.
Thank you.
Okay.
Case of the people versus Adam Sauer.
Ready. People.
Good morning, Your Honor.
Morning.
Timothy Dinan, P49499. I'm here on behalf of Mr. Howard, who now appears on my right.
Your name, sir?
Adam Swords.
All right. What are we doing?
Oh, Your Honor, this morning I spoke with counsel, and my client's asking to tender a plea of no contest to the charge. I understand that people do not have an objection to that and have forwarded to the court a copy of the police report.
That's correct, Your Honor.
This is the one that was sent to me. Okay. I have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Adam Swords.
Sir, it is this court's understanding that you're going to plead no contest to the charge of operating motor vehicle without security. That's a misdemeanor punishable by up to 1 year incarceration, not less than a $200 nor more than $500 fine plus court costs. You understand that, sir?
Yes, Your Honor.
All right. And understanding that you still wish to plead no contest?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right, 2 things about it I have to make sure that you understand, and that means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
I understand, Your Honor.
Still want to plead, and the basis for no contest plea counsel?
Civil litigation, Your Honor.
All right. Sir, to that charge, how do you plead?
No contest, Your
Now,
Honor.
you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
Has he signed an advice of rights?
I believe we tendered it last time, Your Honor, to the court. If need be, I have gone over his rights with him, though.
Yes, all right. We could, yes, have.
Happy to do so, Judge. Flip it over, buddy. And July 2. Thank you. Yeah, he's executed that.
All right. You have any questions regarding any of those rights on that form?
Oh, Your Honor.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. By pleading guilty, you'll be giving up those rights as well as all the rights on the form.
I understand, Your Honor.
You understand you're giving up your right to appeal of right?
I understand, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's in state? Well, promise you anything to get you to plead guilty?
Just what we agreed to, Your Honor.
The no contest plea, Your Honor.
Gotcha. Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has received and reviewed Pittsfield Township Department of Public Safety report for their case number 253831. Any objection to the court having reviewed that report?
None, Your Honor.
All right. Is counsel aware of any inducements, promises, threats that have led to this plea, other than what's been stated on the record?
No, Your Honor.
No, Your Honor.
All right. And the court does not believe that the admonishment regarding misconduct will be necessary because I'm going to immediately sentence him. Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
It would be proper, Your Honor.
Yes.
Court will accept the defendant's plea of no contest to this charge. Anything, counsel, you or your client want to say before I impose sentence?
Judge, my client has a clean criminal record. He has had some financial problems as of recent. He is self-employed. He's also had a lengthy separation from his family. His wife left the country essentially with his children, and it's been a challenge. All the vehicles he drives now are properly insured and properly licensed. And I think my client's earned a valuable, if not very expensive lesson.
Sir, anything you want to tell me?
I believe my attorney represented it very well, but thank you, Your Honor.
Fines and costs of $300, a loader 365 days in jail that is suspended. When do you think you can get that paid, sir?
We should pay $300, buddy. 2 weeks.
Yeah, that's okay.
Your Honor, if you can just give us 14 days, that'll be plenty of time.
I know, stuff happens. So August 1st.
Thank you, Judge.
You're welcome.
Thank you,
Have a
Your
good day.
Good seeing you.
Honor. Thank you.
Oh, thanks for your help today.
Is that it for that block?
Thank you, Your Honor.
All right, that's it for that block. I'll take a brief recess. We'll come back. We'll start our time.
All rise.
All right, well, he goes on recess. Let's go to Jefferson County, Judge Rubber Gloves.
Interlock and use investigator conditions.
Mr. Abshire, your full name is Jonathan Ray Abshire?
Yes, sir.
Mr. Abshire, would you please raise your right hand? Mr. Abshire, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Abshire, you may put your hand down. How are you doing, Mr. Abshire? I'm doing fine, thanks for asking. Mr. Abshire, you represented in your cases by your attorney, Alan Parker. Mr. Parker, how are you doing?
Good, Judge. Thank you.
And
You
Mr.
got it?
Parker, do you waive a record in Mr. Abshire cases?
Sure.
Mr. Abshire, I have before me a document that is titled Information. And this information was filed by the Jefferson County District Attorney's Office. And this information is in cause number 23CCCR 0344. And in this information, Mr. Abshire, it alleges that you, Jonathan Ray Abshire, on or about March 3rd of 2023, while you were in Jefferson County, Texas, that while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Abshire, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Abshire, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? You have to check the third box. That's the third box is for the deal, yeah. Okay, thank you. Okay, now, Mr. Abshire, I have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on a line next to a box that says check no contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of the defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document on paper of the discovery certificate.
Yes, Your Honor.
This document is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir, it is.
Mr. Abshire, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Mr. Abshire, are you a citizen of the United States?
Yes. Except for stage 1. No
It-
objection.
No objection. State's Exhibit Number 1 will be admitted. Ms. Parker, you advised in counsel, Mr. Abshire, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Abshire, your attorney, Mr. Parker, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Abshire, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt.
Yes.
State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
The agreement in this case is 180 days probation over 15 months with $1,000 fine, 80 hours community service, the installation and maintainment of an interlock device, and DWI standard conditions of probation. This is ranking current with his other DWI case, and the state will be dismissing the criminal trespassing for the agreement on these cases.
Okay.
What's the court cost?
And is there 0.44?
Yeah, 4-4.
392. Let's take a look at it. You finished with that task? On the same, you finished with the task?
I am, you told me to leave it there.
Okay, use that one. Well, this one's in the batteries on you.
Okay, Mr. Abshire, the state is offering that you serve 180 days in Jefferson County Jail, but you will not be required to serve any time in the Jefferson County Jail because you'll be on probation for a period of 15 months. During the 15-month probationary period, you'll be required to pay a fine of $1,000 for court costs, $392. You'll be required to pay a DWI conviction fine fee of $100. You will also be required to pay a probation fee of $6 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month, is $188 a month. Will you be able to pay the $188 each month?
Yes, sir.
You'll also be required to perform 80 hours of community service, install an interlock device on any vehicle that's run operated, attend a completed DW education class, have an alcohol assessment, adhere to the other standard terms and conditions of this probation. In this case, will run concurrent with the companion case, cause number 24CCCR 2609. Mr. Abshire, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes, sir.
Mr. Abshire, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Abshire, we will move on to your next case. And your next case is cause number 24CCCR 2609. And in this case, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. And in this information, Mr. Abshire, it alleges that you, Jonathan Ray Abshire, on or about September 26th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated with an open container. Mr. Abshire, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Abshire, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Okay, now, I had to make an adjustment on this one. You can check that first box off and,
It says yes.
yes, no, hit no, apparently.
What do I do? No.
Let's see, probably was trying to send it to her. Let's see, that was, 06. Let's get back on that. See if you can get this stuff. I'm looking at 09 on Abshire. Thank you.
What do you want me to do?
It should be the third box that's checked. That, and then, that just go over range of punishment with it. Okay,
I already have, it's,
yes, it's different, it's the open container, so it's the minimum is not 72 hours, it's 6-day minimum. I had to make that, let me see, we breaks that. 6 days.
All right, we just agreed to straight probation, so in that case, they may need to abandon the enhancement.
Okay, so y'all abandoning enhancement?
That's correct, Your Honor.
Okay. No, I don't think you have to change anything. It shouldn't come up as an open container. Is it coming up as open container on the judgment? Because you're gonna have to redo it. Yeah, because it's open container, the range of punishment would have been different. Let me do this.
Which one is it? You don't see someone.
Okay. Let me erase this here, this open container. Okay, so I'm gonna have to go back over. Now, Mr. Abshire, the state originally filed this case as a driving while intoxicated with an open container, which actually meant that the range of punishment, instead of being 72 hours minimum, would have been 6 days minimum to 180 days. The state is abandoning the enhancement paragraph, and by the state abandoning the enhancement paragraph, the range of punishment goes back to a class B DWI misdemeanor with a minimum of 72 hours, Jefferson County Jail to a maximum of 180 days. A fine that does not exceed $2,000, or you can be given both such fine. Do you understand that?
yes, sir.
Now,
Thank you.
and on page 2 of this document, there's set of initials on the line next to a box that's checked, no particular, which means no contest. Did you place your initials on this document?
Yes, sir.
And on page 3 of this document, there's a signature above the line that's titled defendant. Is this your signature?
Yes.
And on the next document that's titled trial court certification and defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box check states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box is check states that you're waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that statement?
Yes, sir.
I also have a document that is titled Discovery Certification. And do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes.
Now, Mr. Abshire, before you sign and initial these documents, did your attorney go over these documents?
Yes.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
State.
CR 6-1.
No objection.
No objection. States exhibit number 1 will be admitted. And Mr. Parking revising counsel, Mr. Abshire, in this case, is that any evidence that is currently admitted?
No, Your Honor.
And Mr. Abshire, your attorney, Mr. Parker, has advised and counsel you. Are you satisfied with his representation in this case?
Yes, sir.
Okay. Mr. Abshire, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
As with the previous case, the agreement on this case is 380 days probate over 15 months with $8,000 fines, 80 hours community service, the installation of containment interlock device, and DWI's same conditions of probation. State will be dismissing 23 CCC 1453 for this case.
Okay. What's the court cost in this? Oh. No, I'm talking in the second case. Oh, you did, yeah, okay, you didn't have one printed out. Look at it. I know the court cost would have been the same. $392, okay. Okay. Okay, Mr. Abshire, state is offering that you serve 180 days in Jefferson County Jail. However, you will not be required to serve any time in Jefferson County Jail because you'll be placed on probation for a period of 15 months. During the 15-month probationary period, you'll be required to pay a fine of $1,000 plus court costs of $392. You will be required to pay a DWI conviction fine fee of $100. You will not be required to pay a probation fee because you're paying it in the other case. You will not be required to pay your analysis fee because you're paying it in the other case. However, you will be required to pay a reimbursement fee. The total monthly installments will be $108 a month. Will you be able to pay the $108 a month in this case?
Yes, sir.
Okay. You will also be required to perform 80 hours of community service. You will also be required to Mr.
Take your phone.
Mr. Cartwright, please put your mic on mute. All right, thanks. Okay, now, you'll be required to perform 80 hours of community service. You'll be required to install an interlock device on any vehicle that you own or operate. You'll be required to have a DWI, attend a completed DWI education class. You're required to have an alcohol assessment. You will also be required to adhere to the other standard terms and conditions in probation. You also be required to pay Jefferson County DWI education initial evaluation fee of $125 on the day of the police shuttle for the evaluation. You will be required to pay an additional $50. Now, you may not be able to be required to pay the second one because you're paying it in the first one and they run it concurrent. Okay. Now, in a lot, DWI Act, all assessment. This case will run concurrent with the previous case, cause number 23CCCR 0344, and the state will be dismissing cause number 23CCCR 1453. Mr. Abshire, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes.
Do you accept the state's offer?
Yes.
Mr. Abshire, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Abshire, do you have this paperwork? Okay, just have a seat in that second chair, wait for your name to be called. Once your name is called, you'll go to the window, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go, and you have a blessed day.
You too. Thank
All right, thank you. And you're free to go as well, Mr. Parker.
And we're now all free to go as well. Is it just me, or did that hearing take way longer than it probably needed to? It felt like it took way longer, but luckily we have stuff going on in the chat. Let's go to Judge Mom and see what's going on in her neck of the woods, Michigan today.
During his history, he's got nothing, so I'm asking that you adopt it, Your Honor.
Okay, you're with me. Mr. Kristoff, please hit join. The button showed up. Please hit join, Mr. Kristoff. Thank you. All right, and so Mr. Murphy, thank you very much for your service to our country. And the court, in reviewing this report and recommendation, the court would agree, counsel, that there's not a reasonable ground to depart from MCL 769.5. The court does find that the recommendation is appropriate, and this is exactly the type of case that was contemplated in relation to the amendments to the statutes regarding probation. So the court, and let me just confirm, is Brandy Butha? Is there a Brandy Butha here? Okay, that's a named victim, the other person in the vehicle. Sir, I caution you that, and you're not on probation, right? And I'm sure your attorney has indicated that right now you're going to have some licensing sanctions. And if this happens again, there could be much more severe consequences and sanctions, okay? So the court's going to order you to pay restitution amount of $460.75. The court's going to order a $300 fine, $100 screening assessment fee, cost of prosecution $300, crime victim assessment fee of $75, justice system assessment fee of $50. That's a total of $825, plus the $460 in restitution and 75 cents. Sir, if you're in a test right now, what is in your system?
Pardon me?
If you were to test right now, what would be in your system?
Nothing.
Okay. So the total is $1,285.75 when you take into account the restitution. You did post a bond of $250. Do you have any other funds to pay today, sir?
Half that?
If he could split it, Your Honor, he could pay half of the balance today and then half in 30 days.
Okay, so are you intending to pay half? Well, let me just clarify. So there's a $250 bond that you had posted, which leaves a balance of $1,035.75. You can pay $500 today, sir?
Yes.
Okay, so there's a total of $750 that's going to be paid today when we apply your bond. And then the balance of $535.75, sir, when can you pay that?
Next month on the 1st.
Okay. August 1st? Is that yes?
Yes, I'm sorry.
That's okay. All right, sir, I wish you well. I wish you good luck. Thank you again for your service to our country. And please stop over probation and they will process this matter for you.
Okay.
Okay?
Thank you.
Thank you, Your Honor. Nice to see you.
You too, counsel. Let's go off the record. Okay. Also, I understand that the line out run time's out this morning also, so I know that we have another. So I think we're gonna be back and forth with the jails today. Who this is a review.
I don't have a file.
Okay, let me good morning.
Morning.
Okay, which individual is that?
This is Mr. Marshall.
Marshall, okay, I do remember that now, Scott did say that name. Okay, just one moment, we're just grabbing the file so we can put, actually, I think Mr. Holmberg is assigned to him and he's in a breakout room with Lee County Jail. So, okay, it's going to be just one moment, we're going to put you and Mr. Holmberg into a breakout room. Okay. Is Dave can you message Scott? Because I think he's running around somewhere. And ask him if he can bring the file in for Mr. Marshall. please, so we can give it to Jennifer.
We need to say things like, or maybe someone will see the light. We'll see. Thank you. Officer.
Oh, he's messaging Scott right now.
Oh, this is okay, thank you. We're ready. Mr. Serrano.
Yes.
Is it quick? Yeah. I'm sorry.
I know you have a lot going on. Because you have two in custody, so they're reporting right now. Can you, I told Mr. Homer to break out room with the county jail.
Yes, ma'am.
Okay.
Can you please ask him to leave that breakout room, rather than put him in a breakout room with, I'm pretty sure he's the attorney, Mr. Homer's the attorney.
Yes, ma'am.
Who, do we know who has the line down in custody?
I do not, Your Honor.
Okay,
I just messaged him, so he should be
okay.
coming.
Oh, Mr. Sheriff.
Okay, so Riverview, I'm going to move you into breakout room 2, and then I'm also going to move, I'm pretty certain I was told Mr. Holmberg is the attorney for Mr. Marshall. So. Okay. So. Okay. Okay. All right, we are on the record in the matter of the city of Wyandotte versus Aaron Warren, 2596.
Ready?
Your Honor, good morning, Richard T. Serrano, P. 33828, appearing on behalf of with my client. Your Honor, this is the date and time set for the adjourned pretrial. Sir, please state your name.
Aaron Warren.
Okay, good morning. Okay, so, what's the status of the inspection?
Your Honor, my clients told me that someone finally did come out and looked at it and pretty much didn't say anything positive, said most things negative.
No, they did pass it.
Well, they passed that aspect, but I'm saying, we can't do anything today, Your Honor, because number one, Mr. Cayley, I tried to communicate with Mr. Cayley, who's out of town. So we don't know at this point what the disposition is going to be. My client, quite frankly, wants a jury trial on this matter.
Okay, hold on. What do you mean you don't know what the disposition is going to be? What was the property maintenance violation for?
Well, there was a list. You want to know?
When I bought my home, I had a list of 17 pages, Your Honor, of items to renovate and complete on the home.
I understand that. So where?
It's all been completed.
All of it's been completed. So is there communication from the city building department regarding that as to what should be happening then?
You had asked me to go down there after our last meeting.
Yes.
And I went down there. Well, first I stopped at the front desk like you asked me to, and I got this list of all the violations that they've written. It's the same violation written repeatedly.
Well, the sidewalk's done though, right?
Everything's done.
Okay.
So
everything is done. Why are we setting this for a jury trial?
because I've asked the building department to help get rid of all or deal with all of these once and for all, and they won't communicate with me about it.
Okay, now what are those, the other tickets that you have here in this court?
Yes.
Would you like to?
Well,
they're all the same property maintenance.
Okay. Long short of it is my client had to post, what was it, $3,000 bond?
That's part of it.
okay, I understand that you want they're helping having all those matters resolved. The matter before the court here is this matter. So has this matter been resolved in its entirety?
I don't know.
Well, if you don't know, how are we
The
supposed
building
to know?
department was supposed to call me and has not called me.
And my job was to communicate with the prosecutor, who was supposed to communicate with the building department. But when I sent the latest email, Mr. Haley said I'm out of town. So Mr. Zick is here today. He pretty much is saying plead guilty or nothing. So that's where we're at. I told my client that more than likely the court will adjourn it for a final pretrial before the jury trial. I would suggest that, because then we'll probably have all the people that are the players in place for that one.
Well, so here's the procedural history. April 2nd, the court conducted an agreement pretrial. May 7th, there was a pretrial held. We adjourned it so that the concrete could be finished. And then there are a number of violations you do not understand or have knowledge of. Then June 18th, you were all back. The pretrial was held, inspection was scheduled, and you claimed nobody showed up. Then we set it for today for a final adjournment. So now you're stating that there was inspection in the past.
But I don't have any official communication other than I was told it was passed, but then somebody came by and told one of my, someone that was working at my home with me that they were considering further enforcement on something else, but didn't say what. And I've been trying to go down to the building department and get answers, and they refuse to talk to me.
What do you mean they refuse to talk to you?
When I asked about my bond money, a woman walked away and said that I would have to talk to Jesus and that he wasn't there, and that he would call me.
And Your Honor, I've informed my client that if and when there is a trial, one of the issues will not be, should he get his past violation dismissed. We're talking about one case, this one. And he understands that. It's just that we would like to be able to get this Mr. Jesus in a room with myself and the prosecutor to see exactly where we're at. Apparently, we can't accomplish that.
Okay, but since April 2nd, that has not been able, did anybody even attempt to have that happen? Since April 2nd, has anybody attempted to have that happen? That's been 3 months.
Yes, Your Honor, through communication with the prosecutor. I'm not in business to talk to witnesses, although some people would say witnesses belong to no one. These are prosecutorial witnesses, Your Honor. I don't think that Mr. Cayley or any prosecutor would appreciate me going by myself to start grilling potential witnesses.
Counsel, I'm not suggesting that's what you have to do, but my question is, since April 2nd, has there been communication between you and Mr. Cayley requesting a meeting to be set up with the three of you? You, Mr. Cayley, the building department, actually 4 of you, and your client. Please keep your hands out of your pockets, sir.
No, because there was still work being done. Now that the final inspection shows that it's been done, I think this is the best time to say, what else do you want from my client? He's trying to restore a 100-year-old home. He's got people coming by thanking him.
Do you have the paperwork that shows the inspection that it passed?
Do you have it with you?
I don't.
Why would you not bring that with you today, sir? For the court date, why would you not bring that?
I don't have that. I'm so sorry. That's what I'm trying to get from the building department, is all the documentation that you asked me for. I got the documentation from the clerk. I asked the building department for the documentation.
Okay, Mr. Zick? I don't know if that.
Good morning, Your Honor.
Good morning. Mr. Warren, is it possible you could have somebody from the building department come down to the court, please?
Yes, Your Honor. I can make that call right now.
Perfect, thank you very much. We're gonna recall this. We're gonna have it happen right now then.
He's been told to be the guy that.
All right, have a seat, take that with you. And then as soon as they get
All right,
here,
let's go on the record in the matter of the city of Wyandotte versus Gregory Abercrombie, 25549.
Your Honor, good morning. Richard T. Serrano, P33828, appearing on behalf of my client. And Your Honor, this being the date time set for arraignment pre-trial, we've had an opportunity to discuss the matter, understand the nature of the charges, all possible penalties involved, all of his constitutional rights, which he signed a form for that. Thereby, we waive formal reading today's stand. You ask for a not guilty plea to be entered.
All right, thank you. Mr. Abercrombie, your name for the record, please.
Gregory Daniel Abercrombie.
All right, and the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then ask the pretrial counsel.
Your Honor, after pre-trying the matter, there are some issues that I would like to look at further, we suggested a short adjournment for discovery purposes. I would close the discovery order, the prosecutor has no objection.
All right, the court will adjourn this to July 23rd, you're back, or actually July 30th, counsel, you're back that day as well.
All right, Your Honor, 30th, okay. What time, Your Honor?
10 a.m.
Thank you.
As to bond counsel.
Your Honor, my client has no matters pending, except he is on probation, which will be terminated in 36th District, is that where you said it was?
36th District.
In 2 weeks, he'll be on probation there. That's all that's going on, Your Honor. Other than that, we hope the court would allow a personal bond statement.
All right, sir, what are you currently on probation for?
Violation of probation.
You're on probation for a violation of probation?
No, I had a charge in 23 for possession of narcotics.
And you're on probation for that matter?
Yes.
And where did that case originate?
It originated here, Your Honor.
Okay, so it's not 36th District, it's Third Circuit Court, that's felony probation, that's a little bit different from the 36th District Court, as that would be a misdemeanor.
But I'm sorry, Your Honor, that's what he told me, but I did note the conviction that he had from 2024 on his record. I thought that might be the same one, but it turns out that is the same one?
It is the same one,
Yes.
Third Circuit Court.
Okay, now we're.
And so, sir, you were sentenced to 18 months probation,
Yes, ma'am.
and so, did you fail to appear for any probation appointments or hearings or anything?
Yeah, my probation officer said she was gonna violate me, so I never showed up, and they picked me up for a warrant. That's when I was picked up on the 18th, the weekend of Easter weekend,
Okay,
for violation of probation, for not showing up.
and so when were you supposed to have had probation violation hearing, sir? When was the warrant issued for your arrest? Let me ask it that way.
When was it issued?
Yes,
It was issued in December.
okay.
2024.
Yes.
Okay, and so despite your absconding from probation and whatnot, you're still scheduled to be off probation in 2 weeks?
Yes, ma'am. The judge told me if I handled all my responsibilities and my new probation officer put in for an early release. And she said about 2 weeks. She'll let me know for
Okay,
sure.
and then, if you were to test right now, sir, what is in your system?
Nothing. I've been going to classes and I get tested every time I see the probation officer.
Which is how often?
Well, the new one, the last three months, last 2 months,
How often do you meet with your probation officer a month?
once a month.
Once a month, so you're testing once a month. You're on probation for felony drug charge, and now you have this pending possession of paraphernalia, and you test once a month.
Yes. And I also am enrolled in Hydera. I get tested there once a month, but I have class once a week.
Is that part of your probation, sir, or are you doing
Yes, it
it
is.
voluntarily? That's part of your
Part of my
probation?
probation.
Okay.
And
All right, you're not to possess or consume any alcohol or drugs unless prescribed. The court, and you're going to be subjected to random testing. The court's going to have you participate in random testing a bit more frequently than what you're currently doing, sir. Just to ensure, sir, that you are maintaining your recovery. The court's going to order a $5,000 personal bond. The court has also signed the discovery order, so counsel, you'll get a copy of your discovery order, and Mr. Abercrombie, you will get a copy of your bond condition. So just have a seat, and it'll be just a few moments, okay?
thank you, Your Honor.
Thank you, Your Honor.
All right, let's go off the record for a moment. Between probation and CC, probably, but, we're, for the right action, I'll go. Whatever you want.
Let's change it up a little bit. Let's go to Lenawee County, Michael Olsaver. Spend a little time with him.
Okay, Mr. Glazer, are you ready to proceed with Mr. Torres? You are muted, Mr. Glazer.
Yes, I am, Your Honor.
Okay, this is file 25-22298-FH and 25-22299-FH. People versus Randy Torres. We are proceeding today by video conference. We are here for an arraignment. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Good morning, Your Honor. Isaac Sneed on behalf of the people.
John Glazer on behalf of Mr. Torres.
And Mr. Glazer, does Mr. Torres wish to have either of the informations read?
We waive the reading of those, ask the court to enter a plea of not guilty and set this matter for a pretrial in probably just a couple of weeks, not very far away.
Okay. Court will enter a not guilty plea for Mr. Torres in both files and set this for a pretrial conference can do June 23rd at June 23rd at 8:15 a.m. July. Getting the right month.
23rd.
Yeah.
All right, that'll work, Your Honor.
So July 23rd at 8:15.
Yep. All right, I got that.
Okay. All right, Mr. Torres, you can let the officer with you know that you're done with court for today.
Yes, sir.
Mr. Malero, are you ready to proceed with Ms. Julia Eichenberg?
I am, Your Honor. I am ready to proceed.
All right, 1 second. This is file 25-22141-FH. People versus Melissa Aline Juilliard Eichenberg. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, attorneys place their appearance on the record, beginning with Mr. Bannon.
Alex Bayonetto for the people.
Salvatore Malero on behalf of Melissa Juilliard.
And Mr. Malero, where do we stand with the case today?
Your Honor, I would ask to adjourn this out. Working on a plan to get this matter resolved. I would ask the court for 60 days. I think we would be in a position to either have this resolved completely or set it for trial.
Mr. Banetto, anything you need to address from the people's side?
No, Your Honor.
Okay, what we'll do is adjourn this to September 3rd. at 8:15 a.m. Sir Malera, would you do that stipulation in order for adjournment?
Yes, Your Honor, I would do that.
Okay, we're going to be approximately 200 days since the bind over at that time. So if it's not resolved, then I will set it for trial.
Understood. Thank you, Your Honor.
Okay, so Ms. Julia, your next date again is September 3rd at 8:15. You can log in using all the same Zoom information you used today.
Thank you, Your Honor.
All right, let's go to Kansas. Judge Webster has her version of Hollywood Squares going on, so let's check that out.
Sir, you're charged with one count alleging that you were driving without a driver's license in Butler County. This is called a Class B non-person misdemeanor. If you were to be found guilty, the worst possible penalties could be up to $1,000 fine and 6 months in jail. Usually there's a much lower fine and probation, but you have the right to plead not guilty and set this for trial, or you can admit it by pleading guilty. Or if you don't want to admit or deny, but you don't want to go to trial, you can plead no contest. That means you don't admit it, you don't deny it, you basically stand mute legally on the issue, and you will still be found guilty and proceed with sentencing today. Now, you do have, as I told the gentleman before you, the right to an attorney. You can hire any attorney of your choice, and if you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed, or you can waive your right to an attorney and represent yourself. Give me just one moment. There is another point. Do you want to hire an attorney, apply for court-appointed attorney, or represent yourself, sir?
No, represent myself. Declare I'm guilty.
Now, are you from Kansas?
Yeah, Kansas City, Kansas.
Okay. Well, looking at the cases filed in Kansas, the only one I'm seeing come up on the computer is this one. It may be that you would qualify for the county attorney's diversion program. Have you heard of diversion?
No.
It's a program where you go online and apply. There is a fee for applying. I don't know what it is, but if you're approved, you will pay your fine, your court costs, and another fee. And you'll have to show proof that you've gotten your driver's license, and they would dismiss the charges.
Yeah, but no, I do not have a driver license.
Well, do you think you could get one anytime in the near future?
Maybe because I'm on a case with a migration lawyer, but I'm not sure when it's gonna be happen. I'm like on. If that process gonna take like a while, but
Okay.
yeah, I'm not sure when. If it's like on this year or next year, but I'm
Yeah,
waiting
it
for
could be
a
a year
lawyer.
or two. I understand those immigration cases take a long time. Well, you'd have to be able to get it in probably the very near future, within probably 6 months, I would think, but I don't know, but
No, I
that's
don't think it'll be in 6 months.
all right. So if you don't want to go to diversion, did you say you did want or did not want an attorney?
No, well, if I can pay like my fine on payments, yeah, I don't think I need an attorney. I just want to pay the fine.
If you're found guilty by plea or sentencing, I'm sorry, by plea or trial, then I would give you a fine and most likely probation. And yes, I would give you time to pay. I typically do.
Okay.
So again, let's establish first of all that you understand your right to an attorney, and if you can't afford one, you understand your right to apply, and you understand that or not?
Yes.
Okay, and do you want to have an attorney or do you want to waive your right and represent yourself?
I represent myself.
Say that again, please. Carly Wilson just interrupted.
Yeah, no, just represent myself.
Okay. And is anyone making you waive your right to an attorney?
I'm sorry, what?
Is anyone forcing you to waive your right to an attorney or promising you anything?
No.
Then I will accept your waiver of counsel and have the record reflect that you've done this knowing what you were doing and voluntarily. And I'd have that in the journal entry and the docket notes. And then the next order of business is, how do you plead to driving without a valid driver's license?
Guilty.
By guilty, you're admitting the charge that you did drive on March 24th, 2025 in Butler County, Kansas without a driver's license?
Yes.
And according to the officer's citation or ticket, you're on the Kansas Turnpike, also known as I-35 highway, near mile marker 90 north. Would you agree with that to put you inside of Butler County?
Yeah, I was coming to Kansas from Pratt County.
And then you got stopped in Butler County, it sounds like?
Yeah.
Okay, because that mile marker is in our county. All right, well, I will find that I do have jurisdiction. And you said you were driving an automobile at that location on that date of March 24th, 2025?
Yep.
And you did not have a valid driver's license?
No.
And I will accept your plea. Again, though, is anyone making you enter this plea of guilty?
No.
By any threats? Nope, no promises?
No.
And you understand you have a right to trial, but you're giving that up with this plea?
Yes.
Okay. I accept your plea as knowingly and voluntarily given. I find you guilty of driving without a license. Does the state have any recommendations before I pronounce sentence?
No.
Well, let's check with Mr. Gear, who represents the state of Kansas, and see if he does.
$100 fine, court costs, 120 days suspended jail sentence, subject to 6 months of non-reporting probation. This is a defendant who seemingly appears pursuant to the notice to appear date on the ticket. The state's information is that the statutory requirements of KSA 21-2501 subsection B appear to be outstanding, as I am not aware of any appearance bonds in this case, and the state will defer to the court on any issues concerning repayment of the case.
All right. Well, Mr. Ramos, I am going to follow those recommendations, which means your sentence is the following: a $100 fine and $108 in court costs for a total due of $208. Now, you said you need some time to pay that. How much time will you need?
Just like a couple weeks and I'll pay the whole thing.
Would 30 days be enough?
Yeah, 30 days, it should be enough.
All right, you get that paid within 30 days. And do you have your pencil there?
Yeah, I got a pencil.
To find out how to pay that online or through the mail or in person, please call the Butler County District Court clerk. The clerk's number is 316-322.
Okay.
4370.
Oh yeah, I think I got the info on my ticket.
Yes, you do. Okay.
Yep.
So call her and she can tell you how to get that paid within 30 days. I'm also giving you a 120-day jail sentence, but I am suspending that, meaning you won't have to serve that as long as you are successful in completing a 6-month non-reporting probation. You won't have to report to probation, but you're still on probation. And you have 3 conditions. The first condition is violate no laws during the next 6 months. The second is pay your fines and costs within 30 days. And then the third condition, and this is very important, is that you go into that, if you haven't had your picture and prints taken, and I don't see that they arrested you, then you need to set up a time to get that done. And you do have to come back to the Butler County Detention Facility to do it. They won't keep you, but under Kansas law, since they didn't arrest you at the site, you have to come in and get your picture and prints taken. And if you don't, that would be a violation of your probation. If you're found in violation of your probation, you can serve that 120 days in the Butler County Jail.
Okay.
So where is court security 2? Are they still in with the other gentleman?
Yeah, he'll need to go into court security too. Judge, I don't have any kind of paperwork on him. What's the case number on this?
2025 TR 635, and it's under De La Rosa Ramos, under the D's. Alfonso De La Rosa, no driver's license, and he doesn't have to set a bond because he's already been sentenced, of course.
Okay, sounds good. Thanks.
So do you have any questions, Mr. De La Rosa, before you go into the breakout room with the officer?
No.
Okay, then, Mr. McGear, is there anything further we need to address?
Not from the state, Your Honor.
Thank you. Then, please, Mr. De La Rosa, look for that invitation on your screen. When it comes on, click on it and set up a date and time for condition number 3 of your probation.
Okay.
Thank you. We'll be in recess.
All right, since Michael brought it up in the chat, let's go to Colorado, Adams County. They're doing their morning zebra parade.
Compliance with the court. So what I'll do, I'm gonna set bond. Sir, no. Sir, I don't want you to say anything. Okay, you have a very capable lawyer. I don't want you to say anything. I'm just trying to protect your rights. Okay. So what I am gonna do is I am going to set bond. It's either gonna be $500 cash surety or a $50 cash only option.
Would the court consider just bringing him back to court potentially this afternoon or as quickly as possible?
I have no money.
We could resolve this.
Let me see.
Thank you.
On a case like this, that does not make sense. Yeah, that's fine. We'll put him in here in front of me this afternoon at 1:30 p.m. here in Division R.
Thank you so much, Judge.
Thank you.
Yeah, no, that makes sense. All right.
I don't even know what today's date is. It's the second. Okay, I'm up to court today. Let's try to get a deal today. All right, you're done. Division, is it R? Yeah. Okay. Judge, I have Cody Dye here.
All right. All right. Good morning, Mr. Dye. This is 25T7720. Can I have appearances?
Abdiza for the people.
Montana Fay on behalf of Mr. Dye. He appears in custody by my side.
All right, please proceed.
Judge, I am asking the court to grant him a personal recognizance bond. What I'm asking the court to consider is imposing non-monetary conditions like pretrial services, including monitored sobriety, as well as check-in calls. I do believe that Mr. Dye is capable of complying with those. He has, I will note that this is a traffic filing. It's not being filed as the court knows that, not being filed as a felony level DUI. He has a lot of stability in the community, and not just in the community at large, but in our community. He has a residence near Bar Lake where he lives with his wife as well as his son. His son has a lot of special needs. He suffers from a seizure disorder, and he needs really both of his parents there to both financially and emotionally support him. Mr. Dye is the main financial support for the family. He works as a welder. His work has been slow, which I think is happening across the metro area in skilled construction type industries. And so it has been a struggle for him to maintain his home for his family. He's very concerned that being left in custody is going to destabilize both him as well as his family, including his son. I think the back of his CPAT is significant because his last charge was in 2015. I believe I looked that case up, although I've looked a lot of things up this morning. He did not have any failures to appear on that, and there's no failures to appear in any of the cases on his history. So his history is there's long breaks. There's an entry from 2008, then 7 years until an entry in 2005, which is 10 years ago. And we're talking about someone who actually has very much shown that they can comply with court orders. So given that his history is really dated, since the last time he had that DUI, he has embedded himself in the community as someone who is a skilled laborer, who has a family, who has a home, and we want him to keep all of those things, even though we want him to answer for these allegations in court. But Mr. Dye has shown that he's someone that's going to do that. And so I am asking the court to modify this and to PR and to ensure community safety by imposing the strict supervised release conditions.
All right, thank you, Mr. Apiegi.
Your Honor, people will object to a PR bond, but people will not object to lowering the bond at this time. I believe this is a traffic, but it's very concerning that the defendant left a scene of an accident. That is always concerning to people. It's always also a risk to the community. He left a scene of an accident was intoxicated driving, allegedly intoxicated driving. So at this time, people will object to a PR bond, but people will not object to the court setting a lower bond and also applying the, as the defense counsel said, as a condition upon SRP and monitoring sobriety. Thank you, Your Honor.
All right, thank you. So, Mr. Dye, this is what I'm going to do.
Yeah.
Suspense is killing us, Judge.
No, sorry, I'm just writing it down.
That was so dramatic.
Next time I'll bring special music effects. All right. So, Mr. Dye, I'm going to give you a $10,000 PR bond, but that's going to be with the condition that you have a co-signer.
Okay,
Co-sign.
yeah, my wife will.
Okay,
But I can't get a hold of my wife.
I'll call her. We'll
Okay.
take care of that. Okay,
All right.
we'll accept that. Thank you.
So that's going to be the condition. There will also be the conditions of supervised release program, monitored sobriety, and the condition of no driving.
Okay.
Okay.
All right, you're going to be set next on July 9th at 1:30 p.m. Division FAC for an arraignment. And I will tell you, sir, if there's a violation, this will not be a case, and I'm specifically noting where we would just release your PR bond, that would be a forfeit.
Okay. Okay. I'll explain that. To you.
Okay.
Thank you.
Okay.
Should you put that in the minute order?
Okay, Judge, I have, Michael Granado.
Okay, Mr. Granado, come on up. Good morning, sir.
Morning.
This is 25M3367. I have appearances.
Ebenezer PJ for the people.
Montana Fay on behalf of Mr. Granado. He appears by my side. I wanted to alert the court. This is similar to Mr. Brown's case. There's an active probation warrant that he was arrested on, but it's not here. It's 22 CR 2303. It's listed on the back of the sheet as well.
Yeah.
It says he was arrested on it, but he'll need a court date on that as well. So I'm hoping while I'm talking, we can get that worked out. Okay, Mr. Granado, I didn't get a chance to get to the affidavit in his case, but it's an obstruction arrest. So, I'm always very skeptical. I'm sure the court is unsurprised that I'm skeptical of obstruction arrest, period, but I'm especially skeptical of obstruction arrest when there's no other charge, along with it. He did have an active probation case. That's a misdemeanor level probation case. There was a failure to comply with that. So he was struggling already on that probation, and we recognize that. The reason Mr. Granado has been struggling so much is because he had a cancer diagnosis pretty recently, and he and his family have been trying to figure out how they're going to deal with that. On top of the cancer diagnosis, he has struggled with some substance abuse issues, and he was in a rehab recently called Cure West. Is it Cure West? Cure West. It's Cure West, which I am familiar with. I always say the name wrong, but I know it because I know I always say the name wrong. He was working with that rehab program. He had recently left that rehab and was looking for another one with his family. But I think a lot of the complications are coming around the combination of the fact that he's trying to deal with any collateral substance abuse problems he has so that he can get himself in a place to also deal with the cancer diagnosis. So the two things are complicating each other. I am asking the court, given the nature of the offense and the fact that he is dealing with these medical issues, to grant him a personal recognizance bond. He can live with his mom, who also has his son right now, while he works on getting back into a rehab program. I can tell he's genuinely doing it because he talks about how you have to call every week to stay on their wait list, and that's all very true. So while he's in jail, he can't keep calling to stay on these wait lists, and he gets kicked off. But if he's out, he can keep up with his phone calls, and really getting back into that is what's going to help him both with the probation and just with himself. So given the nature of the case, I'm going to ask the court to release him on a PR bond, despite the high CPAT I know the DA is going to mention.
All right. Thank you, Mr. Apiegi.
Well, it looked like defense counsel making this argument for him. Your Honor, this one, I did review this case and it was a struggle for me, but based on, people are going to object to a PR bond, but based on the record that defense counsel have made, I will leave to the discretion of the court, but people do object to PR bond simply because of the history of, the criminal history is a little bit concerning to people, not the offense at this time, but the criminal history, and also look at defendant is struggling to comply with court orders. So we have a concern about his return to court. Thank you, Your Honor.
All right. Yeah, no, it's not especially concerning what the affidavit alleges. But what I'm going to do is this. I'm going to set the other case, 22 CR 2303. That's going to be set on July 7th at 8:30 a.m. Division M as in Mary for the setting of a revocation hearing. I note that the bond was set on his current warrant in that case at $750 cash or surety. So what I'm going to do is I'm going to mirror the bond in this case at $750 cash or surety, but also include a $75 cash only option.
Okay.
Next court date is going to be the 9th, 1:30 p.m. Division FAC for an arraignment.
Okay. Thank you, Judge.
But
Your Honor, I am ready on the Spanish cases.
perfect. I appreciate that, Mr. Brockett. Let's pivot over to.
Let's pivot indeed. Let's go back to Judge Simpson.
That's my finding. Anyway. Yeah, we have someone coming here. Court calls case of the people versus Jacob Treadway.
Conrad Silver on behalf of Pittsfield Township.
Your Honor, Joe Simon, on behalf of Mr. Treadway. Jacob, state your name up here.
My name is Jacob Treadway, Your Honor.
All right.
Your Honor, for arraignment purposes, we waive formal reading and stand mute.
And then we waive formal reading, standing mute. Court will enter not guilty plea.
And regarding the pretrial, we've reached a resolution.
We have, Your Honor, the resolution is I'm gonna add count 2, operating while visiting Eric. Guilty guilty to that add count 2. Accept that guilty plea to dismiss count 1. In addition, there is a PBT refusal civil infraction case before this court. I think it's.
You guys are gonna need to do the plea form for me. Normally I wouldn't require it, but there are new requirements of the court rules, so that he has to acknowledge in writing. So I'll have you fill that out. It's going to be an additional dismissal of a citation. Needs to be noted on what's.
Your Honor, thank you. We'll do that, but I think Mr. Siller was just documenting what he's going to do in a different court. We're not doing.
In that case, not.
I understand.
Oh, okay. Okay. All right.
All right.
You need that number?
All right. I'll pass it on. You can have a seat, sir.
Thank you, Your Honor.
Court calls case people.
Barbara, thank you for the $5. Obviously, you got it to go through now. You say thank you for all you do for the channel. Thank all of you for all you do for the channel. This is a lot more about you guys and a lot less about me, and I appreciate it.
I think Mr. Stiller's on some of the other cases, but.
Conrad Silver on behalf of Pittsfield Township.
Sorry, Mr. Stiller, handling much stuff. Good afternoon, or good morning, Assistant Public Defender Lauren Perning on behalf of Mr. Dunlap on the cases ending in 0353 and 0354.
Good morning, Your Honor. To please this honorable court, Brandon Bird on behalf of Vincent Dunlap on the case ending in 0589.
All right. And what are we doing?
Oh, Your Honor, respectfully, got to speak with brother prosecutor and counsel over here, and we would like to plead all 3 cases to the civil infraction of a double parking.
That's correct, Your Honor.
Yeah, there's a state case, but that wasn't part of any resolution I was involved in negotiating.
I'm not a prosecutor. Detail fraud case. I'm only a prosecutor for the EWS case.
That's why I thought I spoke with you earlier. Awkward.
Well, it looks like we do not have an agreement.
Then, Your Honor, respectfully, can we adjourn this matter to see how his other felonies play out? I know his preliminary exam got pushed back. Last time we adjourned it to see what was going to happen.
Do you want to adjourn yours out?
Please, Your Honor.
I have July 16th or August 6th, which is the preference if you're trying to time it up with an exam date.
July 16th, Your Honor.
July 6th. This being case 589, I'll adjourn that matter to July 16th, 2025, 9 a.m. Bond on that matter will continue.
My cases are the cases with Mr.
And thank you, Barbara, as well, for gifting the 5 memberships. Very much appreciated. You're always very generous to me, so thanks so much.
We had count 2 in each case of double parking. If you accept that admission deed in each case, and it's just the original charge in each case.
That's a correct statement.
That is, Your Honor. Thank you.
Dunlap? Yes. In case ending in 353, do you admit responsibility to the fact that on April 2nd, 2021, Pittsfield Township, that you double parked a motor vehicle?
Yes.
on the case ending in 354 on the date of April 2nd, 2021. Do you admit responsibility to the fact that you double parked a motor vehicle in Pittsfield Township?
Yes.
Court will accept those admissions in each case. Count two, count one is dismissed. In each case, fines and costs are $180, so that's a total amount of $360. That's to be paid 60 days. I'll make it 90 days after release.
Thank you, Your Honor.
Thank you.
All right.
Court does call the case of the people versus Juliet von Oceanbear Martinez. This is Mr. Siller's case.
All right, so on behalf of Pittsfield Township.
All right. Ma'am, can you state your name, please?
Devin Julia Martinez.
All right. Pardon? Yes. Mr. Martinez, this is an arraignment on a misdemeanor complaint that alleges that on or about May 18th, 2025, at the location of Carpenter Road in Pittsfield Township, Washington County, State of Michigan, that you were in possession of drug paraphernalia. Do you understand the nature of that charge, ma'am?
Yes.
That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs, and any substance abuse counseling the court deems necessary. You understand that?
Correct.
All right. And my first question to you is, do you want to be represented by an attorney?
It isn't
Pardon?
necessary. It isn't necessary.
Is it necessary?
It isn't necessary.
Well, it might be.
I said it isn't necessary, so could I just speak for myself?
Okay, what do you want to do on the case?
Just let me think.
Hey, Ms. Martinez?
Yeah.
Are you still, you had other cases a while back. Are you still on probation on those cases?
No.
Okay, so you're not before the court on any other things?
I am. But none of them are job related. And they're about to be finished.
Well, maybe. What other courts are you before, Ms. Martinez?
Is it necessary to expound upon this?
Pardon?
Is this relevant?
Well, it could be, because you could be facing additional sanctions depending on those cases, depending on what happens in this case.
Well, is there any way to live this down? Like have it like
To do what?
have it go like is there any way to like forget about this somehow? Is there anything that I can do like community service or something that could do instead of
Mr. Martinez, you don't have, that's why I think you would need an attorney. I mean, you can proceed on your own if that's what you want to do. But quite frankly, knowing a little bit about your history, I don't know that would be a wise call on your part.
I guess so. like what, like, I suppose.
Ms. Martinez, just answer me this. Are you represented by the public defender's office on your other matters?
Yes.
Okay, don't you think it might be wise if they help advise you on this matter and also help you with those other matters? Doesn't that make sense to you?
In a way.
In a way. Okay, in a good way?
In a way that is like, I can, have this, be adjourned with a bond. Can I know what the bond is?
Ms. Martinez, I don't even have a plea from you at this point.
Oh, please, I'm guilty.
No, I didn't mean that.
No.
So,
I'm not protesting to the allegations. I would like to
well,
just,
hold on. I don't want you saying anything about the offense.
well, I do. I see no way around it. It's plain and clear and simple. And
Well,
there's
I know that, and that's why people get attorneys, because sometimes they don't see any way around it.
but it's clear. It's plain. Like,
Oh, I don't know that, Ms. Martinez.
yeah, I guess I'll go with the lawyer, sure.
You will? Good. Okay, public defender case.
Assistant Public Defender Natalie Pate on behalf of Ms. Martinez. Your Honor, we would waive any further reading. My client stands mute and ask that a not guilty plea be entered. I would ask, Your Honor, for an adjourned pretrial date. However, a more lengthier adjournment. The public defender does represent Ms. Martinez on her other matters. She actually has been referred to the Forensic Center and does have an appointment today with them. So I would ask for a lengthier adjournment to that end, Your Honor.
You should have led with that. All right.
The appointment is today?
When she has the appointment today?
It's scheduled for today per the letter from the center.
Got it. Do you know when the hearing date is set on the other matter?
Her latest court date in circuit court is July 28th, and her bond is denied on that case. So I believe it's the 28th.
Okay. So what I will do is I'll adjourn this matter out to August 6th, 2025, 9 a.m. I'll set the defendant's bond so that she's getting credit because she's being held on that other case. I'll set her bond at a $5,000, 10% bond on this case. Order standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or any illegal drugs. All right. Thank you.
Thank you, Your Honor. Thank you, Ms. Martinez.
Miss Ma'am, it says the Forensic Center is coming to see me today.
It's scheduled for today, but I'm not sure if maybe I don't have the most updated information. So there's a chance it might be rescheduled, but from what I can see, it looks like it was scheduled for today. But either way, we'll be in touch, Ms. Martinez. But you're all set for court here today.
What is your name?
We're all set for court here today, Ms. Martinez, but I'll be down to see you before August.
Okay, but what is your name?
Oh, sorry, Natalie. I did not hear. I apologize, Natalie.
Natalie who? Natalie who?
Natalie Pate.
Pate. Thank you.
All right. Thank you.
Thank you, Ms. Martinez.
Court does call the case, People versus Jacqueline Murray.
Kyle Brill on behalf of Ms. Murray. State your name for the record.
Jacqueline Murray.
All right. What are we doing?
And
The court should be in receipt of a plea form. The defendant is going
just
to
need
be
to-
pleading guilty
Can you
to
just
count
sign
one
that real
retail
quick?
fraud in the second degree. Count two here are going to be dismissed as well as a case in district court.
And today is July 2nd, if you could. And Your Honor, I'm having Ms. Murray fill out the form right now, as well as
Fill out which?
the plea form.
July.
So no, I'm not in receipt.
Not in receipt yet, no. As well as the, just sign that, as well as the advice rights form. And if the court needs some help deciphering my handwriting, I'd be happy to provide it. But it's everything as Ms. Londi stated on the record, as well as an amount of restitution between the two cases for a total of $1,281.57.
I have that she's going to be pleading to a retail fraud second. The 1 year offense. Is that what this is supposed to say?
That's put the wrong time.
All right.
Yeah, my apologies, Judge. That's the error.
And then, well, it's a 1 year offense.
Yes.
I get it, but then there is total amount of restitution. I see the 1281.57.
Yes.
And then that looks like it's off of two cases.
Yes, Judge.
This case and another case. And then it just says that the prosecutor and defense agree that they'll dismiss case 250021 in the 15th District Court.
Yes, Your Honor.
Have her sworn.
You solemnly swear and affirm the testimony you're about to give the whole truth and nothing but the truth. Yeah.
Yes,
State your name.
Jacqueline Murray.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the second degree.
Yes, Your Honor.
All right, that's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, I did, Your Honor.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that you're pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yep.
Yes?
Yes.
Are you on probation or parole?
What? Am I on?
Yeah, are you currently on probation?
No. No, Your Honor.
Okay, let me try it again. I'll break it apart. Are you on probation?
No.
Are you on parole?
No.
All right. Has anybody promised you anything other
No.
than what's been stated here today on the record?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and also because you believe that you are indeed guilty of this offense?
Yes.
Between the dates of May 20th, 2019 and June 18th, 2019 at 3749 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, what did you do at the Target?
Oh,
Makes you think that you're guilty.
I walked out with merchandise.
Okay, so you went into the store, you took merchandise and you walked out without paying for it?
Yes, Your Honor.
Was the store open to the public at the
Yes.
time? Did you have anybody's permission to take that property?
No, Your Honor.
And this property that you took, this was property that was offered for sale by Target?
Yes, Your Honor.
All right, is this on the value then?
Yes, Your Honor.
Was the total amount of property that you took from Target, was that in excess of $200?
Yes, Your Honor.
Counsel, have I complied with the court rule? Well, I won't ask that. Ma'am, I do have to advise you that if I accept your plea and you commit some type of misconduct as defined by the Michigan court rules between the time I accept your plea and the time of sentencing, any type of sentencing agreement or evaluation of this case, the court is no longer bound by. You understand that?
Yes, Your Honor.
You also understand that because of that, if you also commit misconduct, you would not be entitled to withdraw your plea.
Yes, Your Honor.
All right, counsel, are you aware of any other inducements, promises, threats that have led to this plea?
No, Your Honor, and I will let the court know the defendant does have pending felony matters that are not a part of this agreement.
Yes, Judge, nothing else beyond what's been placed on the record. And, we did discuss the felony matters and we are aware that they're not part of this agreement.
And have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2 Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report and determination of restitution. Sentencing in this matter will be
July 9th, 2025 at 10 a.m.
July 9th. Okay, July 9th, 2025. What time? 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
And we'll continue. Court calls case versus Nathan Bell.
Conrad Silver on behalf of the school township.
Mr. Simmons.
Actually, on the table.
Cabral on behalf of Mr. Bell in both matters. So I was
here. No,
I don't believe so, Judge. Unless he's logged in on Zoom, I don't believe so, Your Honor. So I was just very recently appointed to this matter. I don't believe I have a good phone number for Mr. Bell. I'd ask at this time for either an adjournment or a show cause hearing to allow me time to send him a letter to hope to get in contact with him.
bench warrant will issue bond 5,000, 10% each case. Those warrants will issue immediately. He's had previous warrants.
Judge.
Court does call the case people versus Daryl Frederick.
Conrad Silver on behalf of the school township.
Your name, sir? Daryl Frederick. All right. This is an arraignment.
Yes, please.
Sir, you are before the court on a new charge that alleges that on or about May 30th, 2025, at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you were in possession of drug paraphernalia. You understand that charge, sir? Yes.
Yes, sir.
All right. That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs, and any substance abuse counseling the court deems necessary. You understand that?
I do, Your Honor.
All right. First question that I have for you, sir, is do you wish to be represented by an attorney?
I do, Your Honor.
You do?
Sir.
Public defender case.
Assistant Public Defender Natalie Pate on behalf of Mr. Frederick, we would waive any further reading. My client stands mute and we would ask for an adjourned pretrial date, please.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be adjourned July 16th, 2025, 9 a.m. Bond in this case will be set in amount of. Is this the only thing holding you, or you're held by
No.
something else?
Oh, sorry, Your Honor. No, he's being held on other matters, several, and he has court dates on the 8th and the 9th of this month, but also the 30th. So I'd ask for a nominal bond in this case.
Bond will be set in the amount of $1,000, I'll do 10% on that. Standard conditions including no assault behavior, no alcohol, recreational marijuana, or any illegal drugs. And I will put him on testing at community corrections 2 times per week. Placed.
Thank you, Your Honor.
Thank you. Court does recall the case, people versus Jacob Treadway.
Conrad Silver on behalf of Pittsfield Township.
Ready, Your Honor. Joe Simon on behalf of Mr. Treadway. Your Honor, they just informed me that Judge Freshour wants me to come next door right now, but I know this court is higher importance.
I am.
Yeah, so let's get this done.
All right.
And so, Your Honor, I think maybe we should start again. For the purpose of arraignment, waive formal reading and stand mute, pardon me.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. I have before me a plea form that indicates that he is pleading to the charge of operating while visibly impaired and added count 2, the 93-day, $300 offense. Upon a successful plea to that charge, then count 1 would be Yes. As well as a civil infraction. The file noted a PBT refusal would also be dismissed.
That is correct, Your Honor.
All accurate, Your Honor.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes. My name is Jacob Treadway, Your Honor.
All right, sir, it is this court's understanding that you're pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days jail, $300 fine plus court costs. The court could also order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle mobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. And understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you're guilty of this offense?
Yeah, I'm sorry, could you repeat that, Your Honor?
And you're doing this because you believe that you're guilty?
Yes, Your Honor.
April 18, 2025, at the location of State Street in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had about 8 to 10 beers. 3 of them were tall, Your Honor.
All right. Were you stopped by the police or was there an accident?
I was stopped by the police for speeding, Your Honor.
All right. Were you ultimately arrested?
Yes, Your Honor.
You were taken to the station or the hospital?
I went to the station, then to the hospital, Your Honor.
All right. Was there a blood draw?
Yes, Your Honor.
And what were the results of that blood test?
It was 0.226, Your Honor.
Do you have any reason to dispute those blood test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Sir, I do have to advise you that if I do accept your plea and you commit misconduct as defined by the court rule between the time of my acceptance of the plea and the time of sentencing, any sentence evaluation or recommendation is withdrawn and the court is not bound by that. You understand that, sir?
Yes, Your Honor.
You also understand that if you do commit that misconduct as defined, that you would not be entitled to withdraw your plea.
Yes, Your Honor.
You understand that. Counsel, is counsel aware of any other promises, threats, or other inducements that have caused this plea?
No other promises, threats, or inducements.
No, Your Honor.
All right. And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
The court will accept the defendant's plea of guilty to count 2.
Your Honor, if it matters to setting the sentencing date, my client's been screened, assessed. He's commenced on farm recovery group. He's about three sessions completed of that 36-week program.
Well, I'll do my standard referral to Von Schwartz for an alcohol screening assessment. You can check with probation as to whether or not they want to do that, but I'll make that referral to Von Schwartz and the Victims Impact Panel. Sentencing in this matter will be
July 30th, 2025.
July 30th, 2025, 12 p.m. Bond in this case will be set as a $25,000 personal recognizance bond, although the standard conditions, including no assault behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, Your Honor.
I am also ordering a community corrections order for testing out on a SoberLink device at this time. All right,
Your Honor.
Anything further?
No.
No, Your Honor. Wait.
So, but
Okay.
appreciate it, man.
Yep. See you out there.
Go ahead. Bye.
Yes, but just wait for me outside.
Court calls case People versus Matthew Fonseca.
Sorry.
Aaron Silver, on behalf of Pittsfield Township.
Did Joe have something?
For the people.
I did have, but
They'll wait for me.
they will wait for me.
They'll wait for me.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Fonseca. Mr. Fonseca, please state your name for the record.
Matthew Lewis Fonseca.
I think we're here for a pretrial and an arraignment.
Yes. As to the arraignment, sir, there's a complaint that alleges that on or about June 4th, 2025, at location of Washington Avenue near Hogback in Pittsfield Township, that you did have in your possession drug paraphernalia. You understand that, sir?
Yes, I do.
That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court cost, and any substance abuse treatment the court deems necessary. Do you understand that?
Yes, I do.
First question I have for you on that is, do you wish to be represented by counsel?
Yes, I would like to.
This is a public defense.
We'll waive further reading, stand mute to the charges, and I'd request another pretrial date.
Defendant having waived forward reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to July 16th, 2025, 9 a.m. What are we doing on the other case?
I'd ask that it be set for the 16th as well. Mr. Fonseca has a felony that I've been in conversation with the people about. We're trying to do a global resolution.
All right. On the other matter, that being 751, I'll adjourn that to that same date of the 16th. As to his bond in the new case, I will set the defendant's bond at $5,000 personal recognizance bond under standard conditions, including no assaultive behavior or possession of any weapons. There should be no alcohol, recreational marijuana, or any illegal drugs. I will also order that the defendant is to report to the Department of Community Corrections for drug testing. That'd be 2 times per week. And I'm sure, and I'll leave it there. I would. I'm sure you are going to apprise your client of proper attire when he comes into the court.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus Devin Gibson.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Devin Gibson, who is approaching. Please state your name for the record, sir.
Devin Gibson.
Thank you, Your Honor. I'm respectfully requesting an adjournment for 2 reasons. The one being that Mr. Gibson is being held on felony matters with his next court date being the 17th of this month. So I would ask for an adjournment after that date.
August 6, 2025.
Thank you, Your Honor. And the people did make an offer in this case Monday evening after I had met with Mr. Gibson that afternoon. I just still also need to discuss that with him. But thank you, Your Honor.
August 6. Thank you. Court does call the case People versus Jermaine Nathan. 3 cases.
Aaron Silver, on behalf of Pittsfield Township.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Nathan, who is approaching.
Right, Nathan.
Thank you.
Thank you, Your Honor. As to the 2 state cases that end in 0897 and then 0898, I would respectfully be requesting an adjournment into August for Mr. Nathan to get a Secretary of State appointment.
Does he have it set already or no?
No, not to my understanding yet, Your Honor.
Well, during those matters, August 6, 2025, 9 a.m. Bond continued in those cases.
And then, Your Honor, as to the case ending, the Pittsfield Township case ending 0060, Mr. Siller had made an offer to dismiss the misdemeanor and allow Mr. Nathan to plead to admit to the civil infraction of double parking. And I discussed that with Mr. Nathan, and he would like to do that today in that case.
That is correct.
Mr. Nathan, do you admit responsibility to the fact that on or about January 7th, 2017, location in Pittsfield Township, specifically Washington Avenue, that you double parked a motor vehicle?
Yes, sir.
Court will accept that admission to count 2. Count 1 is dismissed, and this is in the case ending in 0060. Fines and cost of $180. When can you pay that?
Get it done by next month.
By next month? When next month?
What's the date today? The second?
The second.
Second of next month. I pay.
August, all right. Well, I'll make it August 4th. Okay?
Yes, sir.
Pay it by August 4th, 2025. You're all set. Thank you. Court does call the case People versus Robin Muhammad.
People. Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Muhammad. Mr. Muhammad, please state your name.
Rahman Muhammad. Thank you.
We're asking you to set this for final settlement, please.
Jury final settlement conference will be set August 8th, 2025, 9 a.m. Jury selection will be set August 11th, 2025, 8:30. Both of those proceedings are in person. Bond will continue.
Thank you.
Court calls the case of the People versus Jessica Fox.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Fox. Should be on Zoom, Your Honor. Yep.
Jessica Fox. I have a Jessica, but I have no idea if that's her. And what's your name?
Jessica Lopez.
That's not her. Jessica Fox. There's no response.
Your Honor, I did speak with her yesterday. We did have a resolution. However, we were going to adjourn due to some further conversations. I did expect her to be here. I don't have an explanation for her failure to appear.
Bench warrant will issue. Bond 5,000, 10%. That warrant will issue immediately. Court does call the case People versus Barrage Scott.
Senator Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Barrage Scott, who is approaching. Please state your name for the record, sir.
Verizon and Tay Scott.
What are we doing?
Your Honor, I'm looking to dismiss the case. Mr. Scott has completed a drug treatment program to my satisfaction.
Any objection?
No objection, Your Honor.
Case is dismissed.
Thank you, Your Honor. Okay.
Court does call the case People versus Eric. Is it Canis or case Casey?
Pastor Lonnie for People.
Hello, Your Honor.
Hello, your name?
Eric James Casey.
Sir, you're here on an arraignment on 2 charges. The complaint alleges that on or about July 18, 2024, at the location of
this courthouse.
33.
Yeah, it all happened in this
Are you
courthouse.
going to interrupt
I'm
me?
sorry.
Or are you going to let me continue with your arraignment?
Okay, I'm sorry, sir.
Which way you want to do it?
I'm not going to interrupt you.
Thank you. Complaint alleges that on or about July 18, 2024, at the location of 4133 Washington Avenue in Pittsfield Township, Washington County, State of Michigan, complaint alleges that you did make an assault and battery upon a Joseph Crossley. Do you understand the nature of that charge, sir? And I'm not asking you whether or not you did it. Do you understand what you were charged with?
Yes.
That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. This could be a consecutive sentence. And if a consecutive sentence can be imposed, if this did occur within a place of confinement, you understand the nature or the penalties in this case.
Yes.
You understand that?
Yes.
Count 2 on that complaint alleges that on that same date and at that same time, you did commit the offense of disorderly person jostling. Do you understand the nature of that, sir?
No, because I don't even know these people. The only person I know is
Do you
Joseph.
understand what you are charged with?
Well, I know what you're charging me with, sir, but
I am not charging you. Do you understand what you are charged with in count 2?
no.
All right, let me just do it formally then. July 18, 2024, the location of 4133 Washington Avenue in Pittsfield Township, Washington County, State of Michigan. Count 2 specifically alleges that on that same date and at that same location that you were a disorderly person. To wit, a person was found to be jostling or roughly crowding people unnecessarily in a public place at that location. Do you understand all of that?
I understand all that.
That is a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. Do you understand those penalties?
I understand this, Honor.
Do you wish to be represented by an attorney?
Yes, I guess so, Honor, because you didn't let me
Public
speak.
defender case.
Assistant Public Defender Natalie Pate and on behalf of Mr. Casey, we would waive any further reading. My client stands mute and we would ask for an adjourned pre-trial date as well as a PR bond, please, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be adjourned to July 16, 2025 at 9 a.m. I will set the defendant's bond in this case amount of a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of any weapons or anything fashioned to be a weapon. Do you understand that, sir?
Oh, yes.
Do you understand also that I am going to order no possession or consumption of any alcohol, recreational marijuana, or any illegal drug?
Yes.
I will also order that you are not to have any contact whatsoever with Joseph Crossley.
Don't want to. I'm sorry, sir.
You are really wearing on me.
I'm sorry, sir. I'm just trying to.
Do you understand the order? That was a question. Do you understand you are to have no contact with Joseph Crossley?
Yes. I haven't had no. I'm sorry.
It's one more time.
I'm sorry.
I'm changing the bond.
I'm sorry.
Is there any other requests of conditions from the people?
There is a request for a no go to, Your Honor, an address. May I give that to the court?
No go to, yes, go ahead.
10245 Talladay Road, Talladay in Willis, Michigan. 48191.
Nope.
Any objection to that, counsel?
No, Your Honor.
All right, I'm going to order that there is no go to that location, 1025 Talladay Road, Willis. Thank you.
Thank you.
Thank
Sorry, Judge.
It's a few minutes early, but I think honestly that's the logical ending point for today. Some people just don't know when to shut up. It's so in them to need to talk. And Michael, your assessment of this gentleman in the chat and about the vibes he gives off, 100% agree. His mouth and his personality are undoubtedly what gets him into trouble and why he's in court. So there you go. All right, my friends, that does it. Be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members, of which we have 5 new ones, so we'll see if some of them show up. Thank you again to Barbara for the super chat and for gifting those memberships. I do appreciate it. I have no idea what tomorrow is going to bring us for court. It could be really busy or it could be dead. If it's dead, we'll play some classic stuff. There's always things we can show. And we'll make tomorrow movie day in the chat. Since we did TV shows and we did music today, we'll do movies tomorrow. You want to say goodbye to them? They're listening. Do you want to say anything? No? All right. Well, I'll say goodbye on your behalf. Deal? All right. Ellie says goodbye. So yeah, we'll see you tomorrow. In the meantime, have yourselves a great Wednesday. I appreciate all of you, and see you soon. Take care. God bless.